So to turn to my sort of hypotheticals to ask the group for help. So I have two situations, and one of them, and I'll be generic if I may use that word. We have a drug which is a very useful drug. There's a controversy about it with respect to a safety issue. We have proposed a supplement. We want to disseminate information about its safe use. There is a fight, a struggle between two parts of the federal agency, and this is a prior approval supplement, so unlike a changes being affected supplement where we can do it and then wait for the FDA to say yes or no, but in fact we're out there. We are not allowed to change the labeling without the FDA's prior approval. We went to the agency a long time ago and said, here's what we think should be out there. We have asked them a number of times, please, can you give us an answer? Can you let us at least disseminate this? Well, one part of the agency thinks this is the right response, and another part of the agency thinks, no, you need something much more draconian. And the agency is completely in deadlock. We have been waiting months and months and months and months and months for an answer. Now, when I was outside counsel, the advice I'd give is, well, make sure you get the agency in writing on that. Well, guess what? They won't put it in writing either. All they'll say is, do not do it. Okay, so what do I do? And if I follow what the agency is telling me, should I really be able to be sued during this interregnum period when we've proposed labeling to the agency and they've told us not to do it? Now, I'm going to have records that say the agency told us not to do it, but do I have a letter from the agency telling me that they'll sue me and they'll destroy me if we don't do what they told me to do? No, I don't have that. Okay, so I'm put to a Hobson's choice. I either directly contradict, A, the law, because it's a prior approval supplement, and B, the FDA telling me not to do this, or I am open to product liability claims for this interregnum period, presumably. I mean, obviously, we will argue against that quite strongly, and I think we'll win, but you get the point. So what do I do? That's question one. And question two is, let's take the problem. Many of us are dealing with the issue now of vaccines. Okay, we do market a swine flu vaccine, but not so much here. And one of the reasons why there have been some delays, let's just say, in the swine flu production is because if you use a 10-vial dose or a 5-vial dose, you have to put in a preservative. The preservative that everybody uses is called thimerosal. Thimerosal has been used in vaccines since at least the 50s, maybe the 30s. It has a little bit of mercury in it. The National Academy of Sciences has said there's no connection between thimerosal and the mercury in thimerosal and autism, and so has a tribunal in HHS issuing a many hundred-page decision. That said, there is controversy out there in the arena on whether or not thimerosal does cause autism, and so we could take the most restrictive approach or the most risk-averse approach and only have single-unit dose vials. Well, guess what? More expensive, more costly, takes a lot more time to fill. You go to 5-dose vials, 10-dose vials, you need thimerosal. The government has ordered this product. The government is going to be, we deliver the product to the government, they are the ones who disseminate it. So, second question, should we be able to be sued when and if someone gets a swine flu vaccine and later, God forbid, it shouldn't happen, but if they happen to contract autism? So with that, I will close and ask guest panelists for free legal advice, which I love.
Well, it sounds like we have unanimity on at least a couple of different points. There's unanimity that the law of preemption is a mess. There's unanimity, I think, that we need a fresh start. There may be even unanimity that the presumption against preemption is not very workable or useful. But what do our panelists have to offer? And Dr. Greve, this is your opportunity to be provocative in terms of what a fresh start should look like. And do you want to answer Mr. Troy's questions as a useful framework for that? I'll start with you, Dr. Greve.
Yeah. I've actually sort of written a little bit about what about what a fresh start looks like. The conclusion to the book Richard Epstein and I did on federal preemption. The conclusion, obviously written by Richard and myself. I stand by every word he thought. And I that is a sort of reasonable start. There are other contributions in that volume that I think are very, very helpful in thinking about these questions, including a contribution by Sam Sakharov and Kathy, another one by Ashley Parrish and Rob Gassaway, who's in the audience. It would take a long time to sort of try and sort this out and lay it out in any great detail. I will say by way of sort of trying to spark controversy, maybe not on the panel, but with the audience, I will say this. I share the sense of, wow, I have now found sort of brothers and sisters in arms. Because I entirely agree that this search for magic words, as Alan rightly calls it, has gotten out of hand. I totally agree that the standard refrain, "Oh, let's get clarity from Congress," is just childish beyond belief. What is significant and demoralizing in this context is that so far, and I'd be so interested in people's reaction to this, so far as I can see, the Supreme Court is moving in exactly the opposite direction. There's ever more attention to magic words, indefinite articles, express preemption provisions, and a pretense that no, if we could just get rid of any purpose in law, if we could just talk about preemption as if Congress had no purpose, we just analyze and pettifog over the precise phrases it uses, we're going to get the questions right. That is so dangerously wrong that I can't believe it's happening, but it is happening. It is coming from Justice Thomas, it is coming from Justice Scalia, it's coming from some other unlikely quarters. It is making an even bigger mess of things, I'm afraid. And the frightening thing is that those justices think they are making theoretical progress. Whereas I think what you really have to do is step back, ask, what is this actually about? This is a form. At the end of the day, this isn't statutory interpretation, although that's a large part of it. It's not about agency deference, although that is too a part of it. At the end of the day, this is preemption law. To make any sense of the world at all, has to be sort of a form of federal common law, if you will. That's not a popular thing to say in these hallways. But it's the truth of the matter, and so what you want to do is come to grips with that insight and then try to get the analytics right. A lot of people on the panel here have worked on that, and I wish us all success. Oh, and sorry, just one more thing. Speaking of which, I think your second problem is not a preemption problem. I think it's a United States versus Boyle problem, and I hope it falls under that, and I hope that case is still good law.
Yeah. If the government buys it, especially, yeah. You know, I'm actually rather disappointed in this program because I usually come to the Federal Society programs and expect to have a big fight, and everybody disagrees with everything I say, and I come out of here, well, that's a good fight. We got some people energized. This agreement is no fun. I mean, it's just not any fun anymore.
Well,
so let me just try.
There still is an opportunity for
all
audience.
right, so let me try. The presumption against preemption, it's actually used in two ways. When they've already reached a conclusion, they put it in there, or they put it in there and say, there is a presumption against preemption, but ... doesn't apply in this case because it's Tuesday or it's December or any other similarly persuasive reason, or there's a strong federal interest, as if that isn't the argument in every case, not the answer to the question.